Don't let this happen to you when drafting a legal custody, child custody award. Picture this. If a parent is awarded sole legal custody of a child, sole legal custody as opposed to physical custody, does that award not carry with it an implicit obligation to exercise that sole legal custody power in good faith and to subserve the best interest of the child? And if so, if a sole legal custodian abuses that power, does that constitute contempt of court? What do you think would happen in a hypothetical scenario like this? And this scenario and one similar to it arise in Utah divorces regularly. Mother is awarded sole legal custody of the child. Both parents adhere to the same religious faith. Both parents desire for the child to be baptized when the child reaches the age of baptism in this church. Baptism is the formal process by which one becomes a member of the family member's church. If a male child is not first baptized in the family's faith, then he cannot be ordained to future church offices such as deacon, teacher, priest, and elder as he ages. Not being baptized when one reaches the age of baptism for boy or girl also carries social stigma in the church, i.e., if you weren't baptized at 8 years of age, you must have done something wrong and been unworthy of it. This is especially hard for young children, as you might have guessed. The child in question is a male and is now or will soon be 8 years of age. The LDS Church's policy is that fathers who are deemed worthy by ecclesiastical leaders to baptize are to baptize their own children. Father has been deemed worthy by ecclesiastical leaders to baptize this son. The child gets to choose whether to be baptized and who will baptize him. In other words, he cannot be forced to be baptized against his will and cannot be forced to have someone baptize him unless he agrees to that person. Child desires to be baptized by his father. Father desires to baptize the child. Mother either articulates no reason why father should not baptize the child, or the reasons she gives for denying father the opportunity to baptize the child are clearly lame. There is no court order that specifically addresses the matter of baptism of the party's children. If mother's refusal to permit the father to baptize their son is an abuse of mother's sole legal custody power, does that mean it's contempt of court too? In my professional opinion, having sole legal custody carries a duty to exercise that power in good faith, the child's best interest, and not arbitrarily or capriciously. But in researching this question, I was surprised to learn that it may not be the slam dunk argument for contempt of court I thought it might have been. In Utah, merely proving abuse of that power, sole legal custody, is not automatically contempt of court. Contempt generally requires a willful violation of a clear, specific court order. If the order or a statute incorporated by the order imposes consultation, information sharing, or other decision-making limits, and the custodian ignores them, a clear argument for contempt exists. Or if it says that something has to happen in good faith or in the child's best interest and doesn't, that would be contempt. Otherwise, responses to general abuse of legal custody power appear to me to consist of modification of the legal custody award, but not a contempt motion. Don't let this happen to you. Plan for the future while you have the opportunity. Practical drafting guidelines? Well, here's some. And they make contempt sanctions available in the event that a parent abuses the sole or even joint legal custody award. Put teeth in that legal custody award order. Include in the award an explicit good faith duty for all decision making, an explicit duty that the exercise of the legal custody power cannot be arbitrary and capricious, an explicit duty to make decisions in the best interest of the child and that subserve the best interest, an explicit duty to provide sufficient advance notice of a decision, and an explicit duty to cite the factual bases for a decision and to clearly articulate with particularity the rationale for that decision, and clear sanctions and fees for willful violations. Doing so makes abuse of the legal custody decision-making power into a sanctionable behavior without having to try to anticipate and identify every specific possible future abuse of the legal custody power.